Episode 4.1 Overview of Negligence. This episode provides an overview of the negligence cause of action and compares it to intentional tort liability. Remember that there are three main types of tort liability: intentional torts, negligence, and strict liability. Intentional tort is not a cause of action in itself. Instead, it is a category made up of multiple causes of action, including battery, assault, false imprisonment, trespass, conversion, etc., each with its own prima facie case. And strict liability is also an umbrella term used to describe a few exceptional situations where the law assigns liability to the defendant even where the harm was caused by accident, unlike intentional torts, and even where the defendant was careful, unlike negligence. Negligence works differently. Most jurisdictions treat it as a single cause of action, not a category or umbrella term. The prima facie case of negligence is made up of four elements: duty, breach, causation, and damages. First, the defendant must have owed a duty to the plaintiff. Second, the defendant must have breached that duty by failing to exercise due care. Third, the defendant's breach must have been the actual and proximate cause of the plaintiff's injuries. And fourth, the plaintiff must have suffered actual harm to person or property. Now, let's compare intentional torts and negligence in more detail. Unlike strict liability, intentional torts and negligence are both based on fault, but fault is established in many different ways. We talked about several intentional tort causes of action, but the basic idea behind all of them, whether we're talking about battery or trespass, false imprisonment or assault, is that the defendant is liable for a deliberate or intentional invasion of the plaintiff's legally protected interest. The defendant's volitional act with intent to cause an invasion of the plaintiff's legally protected interests is what makes her conduct wrongful in the case of intentional torts. Negligence law is different. The defendant is liable for an unreasonable, but not deliberate, invasion of the plaintiff's interests. The duty and breach elements combined are what makes the defendant's conduct wrongful. Under the duty element, the plaintiff must show that the defendant owed a duty to the plaintiff to be careful. In most negligence cases, the duty element is easily established by the plaintiff. And that's because in cases where the defendant is engaged in some kind of affirmative activity, whether it's driving a car or operating a chemical plant, the general rule is that she owes a duty to conduct that activity with reasonable care so as to avoid causing foreseeable injury to other people or their property. Under the breach element, the plaintiff must show that the defendant breached the duty to be careful, or in other words, that the defendant's conduct fell below the standard of care required under the circumstances. Note that the breach required for negligence liability is considerably broader than the act required for intentional tort liability. For one thing, negligence liability can be based on a non-volitional act. For example, if I fall asleep while driving and hit a pedestrian, I would probably be liable for negligence, but not for battery. There would be no liability for battery because when I got behind the wheel, I did not intend to hurt anyone, nor did I act with substantial certainty that someone would be hurt. But there would be liability for negligence because it's careless to fall asleep while driving. Also, under certain circumstances, an omission can be the basis of negligence, whereas an omission is rarely the basis of an intentional tort. For example, if I operate a driving range that's located next to a jogging path, I might be negligent for failing to erect a sufficiently high fence or net to keep golf balls from hitting joggers. I owe a duty to operate my driving range with due care, and I owe that duty to anyone who might foreseeably be harmed if I am not careful. My failure to erect a barrier between the driving range and the jogging path probably amounts to a breach of my duty. Together, duty and breach establish the wrongfulness of the defendant's conduct, taking the place of intent in establishing fault. Another difference between negligence and intentional torts is that the law of intentional torts protects interests that go beyond being free from actual physical harm or property damage. Even if it is only the plaintiff's feelings or sense of dignity that's hurt, that can be sufficient for purposes of intentional tort liability. If I spit in your face, you might not be physically injured, but I could be liable for battery nonetheless, because the contact offends your dignity. Negligence is different. The plaintiff generally must show actual harm, also referred to as damages, in the form of personal injury or property damage. Emotional harm or harm to dignity alone are generally insufficient for negligence liability. If I carelessly cause spit to fall onto your face without deliberately making it happen, I would only be liable for negligence if you can show that you were actually injured in some way, perhaps because you developed an eye infection. It's also important to note that intentional torts and negligence are subject to distinct defenses. The various privileges for intentional torts, consent, self-defense, defense of others, defense of property, private necessity, and public necessity, do not apply to negligence liability. The two affirmative defenses to a claim of negligence are assumption of risk, which is somewhat similar to the consent defense to intentional torts, and contributory or comparative negligence, which is based on the argument that the plaintiff's own negligence contributed to his injuries, and thus his recovery of damages should be reduced or even barred altogether. Before we delve into negligence law in the episodes that follow, there are two key concepts that are important to highlight at this point: reasonableness and foreseeability. You may have already noticed that these two concepts come up again and again in the various elements of the prima facie case and affirmative defenses. You may also have noticed that unreasonableness and foreseeability are related to each other. Whether an act or omission is unreasonable, and thus amounts to a breach of the duty to be careful, for example, depends partly on whether or not you might be able to foresee that harm would occur as a result of the act or omission. And the test for foreseeability begs the question of who might be able to foresee harm. And the answer is a reasonable person. So foreseeability is sometimes referred to as reasonable foreseeability. Both of these concepts are sort of slippery. They don't provide much in the way of a bright line rule that makes it easy to say, yes, that's reasonable, or no, that's unreasonable, yes, that's foreseeable, or no, that's unforeseeable. Making these determinations is often left to the jury. In close cases, the point isn't so much to know the answer, to be able to predict with certainty whether this or that will be deemed reasonable or foreseeable. The point is to learn how to make the arguments on both sides, and especially how to frame those arguments in terms of the relevant legal principles. We'll return to these two concepts repeatedly in the episodes that follow.